persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting in Boston within the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
SJC-11353, Commonwealth versus Michael Robertson.
All right, let's proceed. Yes, good morning.
Good morning, Attorney Michelle Mencken. I represent the defendant appellant, Michael Robertson. A decade ago or so, we were hearing of instances of people hiding cameras in bathrooms, changing rooms, tanning salons, and engaging in peeping Tom activity via hidden camera rather than through the blinds of bedroom windows. And legislatures across the nation responded with video voyeurism statutes. In 2004, Massachusetts enacted Chapter 272, Section 105. And like many similar statutes enacted around that time, Section 105 punishes secret surveillance of a person who is nude or partially nude while that person is in a place and circumstance with an expectation of privacy. Now, the Commonwealth now wants to use Section 105 to address a newer phenomenon of upskirting, that is, using a cell phone camera to take a picture up the skirt of a person out in public. And that's not fair. Section 105 doesn't prohibit that kind of conduct.
Are you saying there's no expectation of privacy?
The requisite expectation of privacy is absent out in public. The expectation of privacy that's required is that the person be in a place and a circumstance where they have an expectation of privacy. Now, the Commonwealth argues...
Yes, but it's expectation of privacy in being so photographed. So that means being photographed up one's skirt, doesn't it?
Well, I think that it means if you read the language of the statute, so photographed would refer back to the manner that has just been described earlier in the sentence, and that is secretly, without consent, while the person is nude or partially nude.
So I guess that's my question. Isn't that really where this turns on, what nude or partially nude means?
It's one of the key factors. I would argue that there are others, but I do take the position that the person has to be in an exposed state, in a state of nudity. The Commonwealth urges that it's only the image that needs to display nudity. That's contrary to the language of the statute. The Commonwealth argues that a person has the requisite expectation of privacy is satisfied because a person expects that the area under their clothing is private and protected against hostile intrusion. And maybe that's so, but if a clothed person is out in public and reveals areas under their clothing, whether inadvertently or otherwise, to plain view, she or he no longer has an expectation of privacy
Can I
in
ask
that
you about
which she
that?
has exposed.
So I'm having trouble figuring out here, are we talking only about those instances where the camera can capture something that the naked eye cannot? I mean, if you're sitting on the tee and someone is very scantily dressed and just by sitting there you can see something that would otherwise be in an intimate area, but you don't, and you photograph it, is that different than the situation of what I take upskirting to be would be that the camera would be able to discern the area of intimacy that you would not otherwise be able to see. Is that right? Am I getting something wrong here?
Well, there's a factual distinction. I'll point out that in this case, there's no allegation or charge that the defendant captured an image or tried to capture an image of anything that wasn't visible. These
Otherwise
two
visible.
women wasn't otherwise visible to somebody sitting at a particular vantage. These women were in skirts and seated on the MBTA,
Not standing on the,
not standing on a platform. There was no allegation that he reached anything under, or had a hidden camera, or a shoe camera, or a mirror, or anything of this sort.
so the allegation is the same as what you could see.
As what you could see. And if it weren't, even if it weren't, if this were a case where somebody had reached under or used a mirror or something like this, or been able to capture a vantage that wasn't visible couldn't be foreseen by the person, by the subject of the photograph, I would still argue that that's not covered by this statute, because the person is still not nude, and that's a requirement of the statute.
You don't dispute that there was secret surveillance.
Well, I actually would suggest that this is not secret in the manner that's contemplated by the statute. The use of a cell phone out in public is not the kind of clandestine recording. For example, this was actually addressed in the wiretapping cases. Glick v. Cuniff in the First Circuit, for example, said that the use of a cell phone openly didn't violate the statute.
Was
because
this
it wasn't
openly done?
Well, there was an allegation that the defendant may have acted furtively, but it also was stated in the allegations that people could see that he was holding his cell phone this way. Witnesses observed the image that was being recorded on the cell phone. The police saw him using the cell phone in this manner. So, there's no suggestion that he said, hey, look at this, I'm going to take a picture of this, and sort of openly said this, but at the same time, it's not secretive in the manner that a camera hidden in a smoke
not a peeping
detector
Tom.
or behind a mirror is secretive and clandestine.
Well, here the intent, though, is whether he's hiding, and at least according to the allegation, as I recall it, it wasn't that he was just it was holding it by his side and turning it in a way that could capture, as though he were just standing there with a cell phone in his hand. That's the allegation. So,
That's the allegation.
but more importantly, maybe, are we focusing? Well, let me let you finish.
So back, I think, to Justice Link's question, if you're seated on the train and you have exposed areas of your body, I think even the Commonwealth concedes that what you've exposed is open to plain view, and you lack an expectation of privacy in that. For example, the Commonwealth refers to one of the pictures that's in the record appendix of the gentleman on the train whose buttocks are exposed, and an onlooker has taken a picture of this and posted it on the web. And the Commonwealth concedes that the exposure there, even if it was inadvertent, it's not protected by an expectation of privacy that society recognizes as reasonable.
Is there any difference between what might be exposed to the eye as opposed to what's exposed to a camera, someone taking a picture of it for having a permanent image of it?
Perhaps. It's not addressed in this statute. This is an issue that the legislature may wish to address. They haven't done so. And it's not this court's prerogative to read these new interpretations and nuances into a statute that wasn't drafted with that intent. I would also point out that if it is offensive to somehow sneak a camera up under a hidden area of clothing, that is offensive no matter where you are. And then the question arises why the legislature would have a requirement that a person be in a place with an expectation of privacy if that was what was intended to be covered. It becomes a superfluous word.
Well, I mean, this statute was passed, I guess, at the nascent stage of cell phones, perhaps perhaps before people understood that they could have this other purpose. But does the fact that the legislature did not anticipate this mean that it would not necessarily apply? I mean, Commonwealth, I'm sure, will argue that regardless whether the legislature anticipated this particular use, the language nonetheless covers it to the extent that it is truly upskirting. I mean, you're describing something which is not upskirting, and I guess the record isn't clear whether this is truly upskirting, but I understand upskirting to mean putting the camera in a place below the skirt so it's looking up at a place where the eyes would not otherwise see.
Well, I think it's important whether the citizenry and law enforcement and the judiciary can discern from the statute that this language clearly covers the situation that you've described. Nudity is a concept that's readily understood. You have to be in a state where you're exposed. And the scenario that you're describing is not clearly covered by the language of this statute that requires that you be in a place as well as a circumstance where you have an expectation of privacy and that you be nude or partially nude. So expanding, reading the language, massaging the language to fit this scenario creates a variety of problems, vagueness, which I've just touched on, and also overbreadth. Imagine that a woman is breastfeeding in public, and somebody who is morally opposed to breastfeeding in public, or a journalist who is aware that this is an interesting issue, wants to capture a picture of this. And the woman maybe has a shawl draped or something to try to maintain some level of modesty, but the onlooker is alarmed at the immodesty or the potential immodesty and captures an image from a vantage where breast is exposed in order to document what they perceive as a problem. Now, that person, under the Commonwealth's reading of the statute, would be guilty of violating Section 105, and that's clearly protected conduct.
But I guess I'm concerned not so much with this statute, but with your view that the reasonable expectation of privacy would not include upskirting, because I can imagine an example of paparazzi seeking to upskirt celebrities and then managing to put somewhere those photographs, and the claim there would be that would be an invasion of privacy.
Well,
would you agree it would be an invasion of privacy?
I agree that an invasion of privacy, that in the invasion of privacy tort context, the expectation of privacy certainly can extend to the areas under one's clothing. I think that expectation of privacy has been defined in a certain way, has been limited in a certain way by the language of this statute. And so this particular statute doesn't provide that. This particular statute provides protection to people who are in places that are suitable for undressing when they're in a state of undress.
So if, maybe this goes to maybe the vagueness. So if the photograph that the person took, the defendant or putative defendant took, upskirting, was of someone who the underwear covered any part of the body that fits within the definition of partially nude, that would not be a crime, right? So it really depends on what kind of underwear the person has on? I mean, is that your argument, that you can't enforce that?
I think that when you interpret the statute the way the Commonwealth does, you do get into situations where you have to question what sort of underwear was the person wearing. Did they take reasonable precautions to cross their legs on the T? And it becomes a very dicey sort of prosecution. And it seems, frankly, absurd to me that the statute would provide protection to people who were wearing a thong or no underpants, where somebody who was wearing underpants wouldn't be protected because they're not in a state of nudity where somebody in a thong may be. If it's an invasion of privacy to upskirt, it should not matter what's exposed under the skirt. So I just want to address the Commonwealth. Getting back to that, the Commonwealth does talk about that it shouldn't really matter whether the person is actually nude under, because in this case, for example, the defendant is only charged with an attempt. And that notion would be that he hoped to capture an image of partial nudity, but was foiled in that attempt by the unforeseeable eventuality that the woman was actually wearing underpants. And this also, to me, yields an absurd result, because the majority of people are going to be properly attired on the train and are going to be covered. And if anybody who's taking a picture of somebody on the T can be supposed to have hoped that the blouse would gape or the shorts would gape. Anybody could be convicted of attempt under the scenario that the...
So if we agree with you, what's the rule of the holding in the case going forward? Can people then just pull out their smartphones and take pictures wherever they are?
I think that this would be a case, like many others, Rahim is one that's cited in my brief, where the court can suggest to the legislature to take a look at this statute. There is, as I've pointed out, proposed legislation pending in both the House and the Senate before the Judiciary Committee right now that is an attempt to address upskirting. It specifically covers surveillance of the intimate areas, and they talk about naked or undergarment-clad genitals. And I suggest that this court could suggest to the legislature that it address this issue, since this statute does not.
Thank you, Counsel.
Thank you.
Good morning. May it please the court. Kaylin Campbell on behalf of the Commonwealth.
Other states have amended their statutes to be explicit on this point. Why isn't that the right course here?
Your Honor, I don't think it's the right course here, specifically as it relates to the defendant's argument, and I would point the court towards the proposed legislation, which, while it does change substantively the statute to include intimate areas, it does not change the place and circumstance language. So looking at the legislature, even if it's considering changing it, which it is, it's considering it changing it to only change the area of the body that's photographed.
In this case, is it the Commonwealth's position that because the person had underwear that covered, that it's an attempt?
Yes, Your Honor. The statute
So what isn't an attempt?
What isn't an attempt is when I think it's important to look at the 5 factors, the 5 elements of the crime, where the photograph or the surveillance has to be willful, and it has to be done with the requisite intent to specifically secretly hide or conduct such activity.
What are the circumstances that you're alleging were here? Is it that the women were seated on the MBTA?
As to the first one, I believe the woman was seated, but specifically in the application for criminal complaint, it states, and this can be found on page 50 of the record appendix, that a witness observed the defendant taking a photograph up a woman's skirt.
But where was the woman?
I believe she was sitting on the train.
So she was sitting on the train?
Yes.
And he wasn't in a position below her?
There's no evidence as to what his position was or the positioning of his phone. I would also point the court towards a record appendix.
But there's that it was at his waist.
In the second allegation, the second charge of attempted, there is evidence that he held the phone at his waist. He was described as being 2 or 3 feet from the woman, and he directed it at an area, I believe it said her crotch, but there was specific, at least an allegation in the application for criminal complaint that it was directed to reveal her crotch area.
Is there any indication that the camera could see things he himself could not see?
I believe so, where it specifically says, at least to the second charge, that it was capturing the area of her crotch.
But his eyes could too.
I don't believe his eyes could. His eyes were not by his waist. There's no allegation.
Well, you don't know what was, if you're seated directly across from somebody, you can often see quite a lot.
Well, there's no allegation that he was seated.
Uh-huh. So you don't know where he was.
But somebody
No,
might
I believe
have been.
At his waist, he would be perhaps at her head level.
There's in the application for criminal complaint, there's no specific evidence as to their heights. I believe it says that the defendant was standing, that he did have a cell phone by his waist, that he was standing 2 or 3 feet away from her, that he put his phone in a position to direct it to the crotch area underneath, this was a female officer, her skirt. So I do believe that from that is a reasonable inference that it was capturing an area that someone standing eye level wouldn't be able to see.
But somebody
Somebody
sitting would.
seated could.
Your Honor, I don't believe that that's true.
Doesn't it all go to, sort of the expectation of privacy if you are putting yourself in a position where, things can be seen?
Yes, Your Honor, and I think that's important. I think it's critical to the analysis here, and I think the expectation of privacy, I disagree with my sister that the expectation is just in a place or circumstance. giving every word in that element meaning. It's a place and circumstance where an individual would have an expectation of privacy not to be so photographed, videotaped, or surveyed.
But who was nude or partially nude, that's also part of it.
That is, Your Honor, but
I don't think people consider themselves partially nude who are wearing underwear, frankly.
Your Honor, I believe that you would consider that area, if someone causes the exposure of that area, to be partially nude. And I would specifically turn you towards the definitions as supplied in 105 Section A, in which it defines, the legislature has defined partially nudity as the exposure of human genitals, buttocks, pubic area, or female breast below the point immediately above the areola. Now, importantly, it doesn't...
By the person.
No. It doesn't say who has to cause the exposure. It just says exposure. And if you look at the common definition of exposure, it means, and I turn to Webster since this is a source that was readily available to the legislature when they wrote this, exposure is defined as the fact or condition of being exposed or the manner of being exposed. Exposed is defined as to cause to be visible or open to view. Now, there's no, in that definition, there's nothing to say that it's the victim herself who has to cause the exposure. But not only that, I would point the court towards its case law concerning strip searches, specifically Commonwealth v. Morales, 462 Mass at page 341.
That's where somebody pulled down the pants of the defendant.
And he lifted the waistband so the defendant's buttocks became visible.
To others than the officer who was looking at him.
But specifically, this court says that that officer caused the exposure of that area.
Right. If you pull the waistband down so that everybody who's standing there can see, it seems to me that's.
Seems to me you're torturing the word exposure to try to fit it, because you're going to have trouble convincing us that this works the way you want it to work. It's hard to imagine, even if you're correct about part of it, that that someone photographing up a skirt the person doesn't have an expectation of privacy. I get that part of the argument. I certainly would have an expectation of privacy and not expect someone to take a cell phone. But the part about exposure, I think, is problematic for you.
Your Honor, I disagree with that because, and I would point the court again to 105A, which specifically contemplates, when it's talking about surveillance, the ability of an individual to use certain devices, such as a cell phone, to aid in viewing areas. And I think when you think of a cell phone, it definitely is the type of device that could be used, put at a certain angle to cause the exposure.
That's right, such as in what I think this probably contemplated at the time, putting it in attics and being available, even if you yourself aren't in the attic, watching someone in the bathroom, something like that.
I still don't get it. I mean, you've done a nice job of trying to sort of fit Webster's dictionary in here and twist the words around to make them marginally applicable. But no common sense reading of this statute would include the conduct you're talking about, would it?
I disagree with that, Your Honor. Where there is nothing in the statute that explicitly says who has to cause the exposure.
Whoever willfully photographs another person who is partially nude.
Yes.
Is that clear?
Yes.
And you sitting on a train are partially nude?
Yes. If you
fully dressed?
Yes, if you read it in conjunction with 105 Section A.
So everybody in this courtroom is partially nude?
Could be partially nude, yes.
Not could be, is.
Is.
Well, not.
I guess we are.
According to your definition, depending on where the camera may be.
Well, it is that the person with the camera can use the camera as an aid to expose your partial nudity. Yes.
Make someone partially nude.
Yes.
You're not partially nude now, but if I take a photo of you, maybe you are.
No, I disagree with that. I'd say areas under my skirt, which I've taken the proper precautions to maintain my privacy, yes, they contain partial nudity because they contain the parts of my body enumerated by the statute.
Even though you have clothes over them?
Yes, because I've taken the necessary precautions to exhibit a subjective expectation of privacy. Now, it could be that a person uses a device to expose this partial nudity because they could use a device to expose these areas of my body.
The legislative history here.
Yes.
Is it what your sister says, that it really was, at the time it was passed, the goal was peeping Toms and putting cameras and
Locker rooms and places like that.
It may be, quite honestly, I wasn't able to find anything that was as explicit as that. I can tell you about the proposed legislation currently, specifically as to Representative John Skyback. He specifically has moved to amend it to include these intimate areas based on an incident in East Hampton, including a individual who was a volunteer with a video camera. He would tape things such as public event meetings, and when he was taping this, individuals noticed that he was using the camera to zoom in on certain parts of women's bodies, specifically their cleavage, and he was using it to try to upskirt these individuals. So
Down blousing now, we have
down
upskirting
blousing
and down blousing.
upskirting. So this individual was doing that. I'd say that defeats my sister's argument that this only would apply to a private place, as specific.
But that's a piece of pending legislation that's not before us. Lots of states have, as a result of incidents like you have just described, passed very specific, explicit laws at this very subject. We could certainly do that too, couldn't we?
You could do that, Your Honor. I'm saying it's not necessary to do that here. I would also say that unlike those statutes, this statute is different in that it contains different elements, specifically the fourth element that ties the reasonable expectation of privacy to both the place, the circumstance, and the manner in which the person is surveyed. And I think that's key here.
May I ask, in your opinion, is there a difference between the expectation of privacy for one who observes using their eyes as opposed to the expectation of privacy with a camera? Is it all the same?
I would say, as to this, so when you talk about expectation of privacy, I think that it's appropriate to use the traditional analysis and ask subjective and objective. I think as to eyes, it necessarily, yes, I think it's different because I think that the technology can be used to cause a further invasion that an individual.
But it's got to, I mean, you got to, I mean, I take it, in this case, as you said, he's at least 3 feet away. It's not as though he has put the camera up the skirt physically.
And I don't think that's necessary.
But it means somebody could see just what the camera is seeing.
I disagree with that because of the angle he was holding the phone and because of the capability that cameras, such as cameras on cell phones, have, the ability to zoom into an area to see it in more detail than you necessarily would be able to see with your own eyes.
But you don't even know if he was standing or sitting. And if he was standing, you don't know anything about the angle of the camera.
I disagree with that, Your Honor. I would again point you towards the application for criminal complaint in which it says specifically to the second incident that he was standing, that the camera was at waist level, and that it was directed in such a manner. However, these are all things, this is all evidence that the Commonwealth would elicit at trial to show beyond a reasonable doubt that the defendant is guilty of committing this crime beyond a reasonable doubt. The problem with here is that we haven't gotten to that stage yet, so it's impossible to answer your questions because the Commonwealth has not been put to that burden of proof.
Now, going back to legislative history, what meaning do you give to subsection D, which expressly says this does not affect changing rooms where they maintain some security, meaning security cameras, in order to protect against theft? I mean, does that not suggest that we're talking here about locker rooms, changing rooms, that kind of bathrooms, that kind of context?
Yes, Your Honor. It does suggest that that is one of the places and circumstances that the legislator contemplated. I don't think that necessarily means that they weren't contemplating that it could be applicable in other places and circumstances.
And would they use the terms nude or partially nude to mean what you say it means if that's what they intended?
Your Honor, admittedly, this language is not the best language. I would agree with that.
Well, maybe, I mean, arguably, one could say it's the best language if the focus of the legislature was to guard against secret cameras in locker rooms, changing rooms, bathrooms. It's perfectly good language for that.
While it could be, yes, that's true. I don't think that you can read that to exclude other places and circumstances that it could apply to, especially where the type of surveillance, the photographing, the videotaping is directed at the parts of the body that do contain the enumerated body parts that are spoken of when they speak of partial nudity.
All right, let's assume you're right, okay? And let's assume that somebody is doing a piece on people in subways.
Sure.
What can they photograph and what can they not photograph to be in compliance with the law?
Importantly, I think that they could, again, I would point the court towards the elements of this crime, specifically the third element, which requires that the person taking the photograph has to have the intent to secretly hide or conduct such activity. I don't know in your hypothetical whether that necessarily would be the case where they are taking a
Well,
picture.
I assume they're trying to get candid shots, so the nature of a candid shot is probably not to say smile for the camera.
Sure. Sure. And in that instance, I believe it would be a jury question in which they would ask at that area whether the individual who is sitting there had a subjective or objective expectation of privacy that they would not be surveyed in such a manner.
But doesn't that make it a bit difficult to do these kinds of photos if you're at risk, depending on what you may photograph, that you're going to find yourself in court?
Well, Your Honor, while that may be true, just because an individual wants to take such a photograph doesn't mean that the state doesn't have the ability to reasonably legislate that type of behavior. I would point the court towards such street artists such as Shepard Fairey. Just because they wish to spray paint on buildings and that has artistic merit doesn't mean that they have the ability to do so and
Are
not
you
be prosecuted
suggesting
by
that
the
even
law.
if there were a statute, like other states that have statutes, more explicitly define upskirting as a crime, you'd have the same issue about the candid camera photographer journalist?
You may, but so long as the statute is not at the content of the photograph, I believe that it would pass constitutional muster.
Can I just ask you one question?
Sure.
If I understand correctly, the attempt here, the reason it's an attempt is because nothing that fits within the definition of partially nude was shown in the photograph. Is that right?
Yes, Your Honor.
So is there any limit to attempt?
Well, Your Honor, yes, there is. There has to be an overt act to commit the substantive offense. And here, where he did aim his camera specifically at areas.
So it becomes a statute about aiming your camera, basically.
Well, Your Honor, that's specifically contemplated by the language of this statute, where it says that electronic surveillance is defined to view, obtain by use or aid of a camera. He used the camera to obtain this person's visual image. Specifically, he was trying to obtain the visual image under a skirt, which contains the enumerated places, the enumerated body parts.
Counsel, we're going to have to leave it there. Thank you very much.
Thank you.